Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. Hey, you know, we talk about this kind of post-Bruin enlightenment that many courts are going through, some of this soul searching where we're able to go back and take a look at some old laws and kind of view it through the more modern lens of Bruin. And we're beginning to discover that, you know, maybe some of these statutory schemes are kind of unconstitutional. Well, if you recall, we did this video a couple months ago. It was about an Obama-appointed judge who had that exact epiphany and struck down a long-standing federal gun law. Well, guess what? It's happened again. Yeah, but this one is really unique, and it's one that I'm not certain I actually agree with, but I'm going to ask you all what you think. So today, let's slow it down, let's geek out, and let's talk about an Obama-appointed judge strikes down another federal gun law. Okay, here's what we're talking about today. We're talking about the case of United States v. Carbajal-Flores. It is a case that is filed in the United States District Court for the Northern District of Illinois. It is a case that challenges the constitutionality of 18 United States Code Section 922G5. Many of you are probably wondering, what the hell is 18 USC 922G5? That particular statute reads as follows. It shall be unlawful for any person, 5, who being an alien, A, is illegally or unlawfully in the United States, or B, except as provided in subsection Y2, has been admitted to the United States under a non-immigrant visa. Okay, so under federal law, if you are a illegal alien, undocumented worker, newcomer, I know we got all sorts of things, but if you're in this country without lawful authority, that does in fact actually make you an illegal alien, federal law says that you cannot possess a firearm. What the court here has done, however, is struck down 18 USC 922G5 as it relates to this defendant. Now, I want to be really clear that the only illegality that the defendant in this case was ever accused of was being in the country illegally. By all accounts, he had lived a very law-abiding lifestyle, had been a productive member of society, and had possessed the firearm for the same reason that all of us possess firearms, which is self-preservation. So the only illegal act that Mr. Carbajal-Flores could have ever been accused of is unlawfully crossing the border into the United States, making him, what, one out of like 8.5 million in the last 3 years alone? Now, the court, in reaching this decision, and this is really important, is actually relying on two other lower circuit cases. One is Range versus Attorney General of the United States. That's a case that's sitting before the United States Supreme Court right now on a petition for certiorari. The other case, and this is the one that the court really ended up hanging its hat on here, is the case of Atkinson v. Garland, which was a constitutional challenge to 18 USC section 922G1, which actually prohibits possession of firearms by people who've been convicted of a felony or are currently under indictment for a felony. Now, in the Atkinson case, the court there carved out kind of a 5-part test, which we're not going to get into today, lest us end up with about a 22-minute video here, but a 5-part test to kind of analyze exactly how we go through the historical analogs necessary to determine whether or not a statute will survive under the Bruin analysis. Now, the Atkinson court had actually found that 18 USC 922G1, the prohibition against those previously convicted of felonies or currently under indictment, did not survive a constitutional challenge. And what the court has done here is basically said, listen, if G1 doesn't survive a constitutional challenge, neither does G5. The court specifically ruled, this court previously held that 1, Carbajal-Flores' conduct is covered by the plain text of the Second Amendment. Nothing has occurred that would cause the court to depart from its prior ruling. Although the Second Amendment's plain text presumptively protects firearms possession by undocumented persons, that does not end the analysis. Under Bruin, if the government can show that the felon dispossession statute is part of the country's historical tradition of firearms regulation, then the statute survives. Thus, the court will reanalyze the historical tradition with Atkinson's guidance. Now, the government made an argument that if I, unfortunately, was working as a solicitor general, I might have made the same exact argument, which is, this is an illegal alien. This is an undocumented individual. This person is not considered under the people as contemplated in the Second Amendment. The court put it this way. The government argues that the historical record establishes that legislatures categorically disarmed 1, individuals who were not members of the political community, and 2, individuals who threatened the social order through their untrustworthy adherence to the rule of law. But then completely backs out of it, relying on Atkinson. This court recently issued opinions guided by Atkinson on identical Section 922G1 challenges that discuss the government's position regarding the untrustworthy adherence to the law, historical analog. Because the government's arguments are identical in this case, this court adopts and incorporates the reasoning of those opinions as to the finding that Section 922G5 is facially constitutional. Okay, so the court finds that the law is facially constitutional, but then here's the rub. As applied to Mr. Carbajal-Flores, the court makes a contrary finding that the statute is unconstitutional. How do they do that? They do it as follows. The government argues that Carbajal-Flores is a non-citizen who is unlawfully present in this country. The court notes, however, that Carbajal-Flores has never been convicted of a felony, a violent crime, or a crime involving the use of a weapon. Even in the present case, Carbajal-Flores contends that he received and used the handgun solely for self-protection and protection of property during a time of documented civil unrest in the spring of 2020. The court finds that Carbajal-Flores' criminal record containing no improper use of a weapon, as well as the non-violent circumstances of his arrest, do not support a finding that he poses a risk to public safety such that he cannot be trusted to use a weapon responsibly and should be deprived of his Second Amendment right to bear arms in self-defense. Thus, this court finds, as applied to Carbajal-Flores, Section 922G5 is unconstitutional. Okay, now, here's what I'm going to leave with you. Is this a good ruling? Yes, we typically applaud any advancement of Second Amendment rights or any eroding of federal gun law. But is Mr. Carbajal-Flores truly a member of the people as contemplated by the Second Amendment? Because if he's not, then the plain text of the Second Amendment does not cover his activity. And my gut instinct was, just to let you know what I had gone through, is my gut instinct was, of course he's not. Of course he is not. But then I got to thinking, like, well, wait a second. Does that mean that Mr. Carbajal-Flores would not have Fourth Amendment protections and the government could just kick in his door anytime they want without a warrant, without probable cause, reasonable suspicion, or anything like that? Does that mean that Mr. Carbajal-Flores, if he was arrested, would not be afforded Fifth Amendment protection, so he didn't have to testify against himself or self-incriminate? Would he be afforded Sixth Amendment protection of right to counsel? The answer to that is clearly yes, he would. And then, of course, there's the Eighth Amendment protections against cruel and unusual punishment. That would certainly be afforded Mr. Carbajal-Flores as well. So it's a very, very interesting opinion authored by Judge Shara Johnson Coleman, a Barack Obama appointee. This now makes 2 federal gun laws in the last couple of months that have been struck down under a reanalysis using the correct test as announced in Bruin by 2 Obama-appointed judges. So listen, I am really anxious to hear what all of you think about this. Please let me know down there in the comment section below. The case, once again, is United States v. Carbajal-Flores. We'll link the ruling up down below so that you can geek out on it for yourself. In the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it's also down there in the description box. And then let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.